the sledgehammer of the Corporate Affairs Commission will be hit on most companies who fails to comply. We need to understand that incorporation of a company does not necessarily just start and end by merely filing your annual returns. It is bigger than that. If you take a look at your business letterhead, your business cards, receipts, invoices, to you, it may represent a masterclass of the graphics design and your corporate identity, your brand identity. But for the Corporate Affairs Commission, it may just readily represent an illegal document that has failed the litmus tests of corporate compliance.
Surprise!
On the 8th of July 2026, the Corporate Affairs Commission issued a circular that will take effect on the 1st of August 2026. The said circular seeks to enforce non-compliance by companies, businesses of failure to specifically disclose the particulars of the directors, proprietors, as the case may be, of these establishments on their business letterheads, trade catalogs, receipts, invoices. The CAC, the Corporate Affairs Commission, by this act, sought and indeed seeks to specifically operationalize the provisions of the Company and Allied Matters Act 2020, particularly Section 304. The said section provides and stipulates that a company, businesses, entrepreneurs, and even directors of the said company must specifically disclose the particulars of the directors in this format. First and foremost, the name of the company must be disclosed on the letterhead or business letters of the company, invoices, receipts, trade catalogs, show cards, etc. The ROC number, the company registration number, must be displayed on these documents. The particulars of the directors as follows: the forenames or the surnames and the surnames of the particulars of this director. Also, if perchance your company has a foreign employer or a foreign director, a director who is not in Nigeria but working in a company within Nigeria, you must disclose on your business letterhead the particulars of the said director. These specifications may appear easy on the eye. As we kick off, the sledgehammer of the Corporate Affairs Commission will be hit on most companies who fails to comply. As a matter of fact, subsection 2 of section 304 makes provisions for strict liability offense for failure to comply with the said regulatory dictates. Furthermore, section 304 and section 729 with the Company and Allied Matters Act must be read pari passu, as they readily demand the same responsibility from the company to specifically disclose the particulars of its directors, the name of the company, the ROC number on its business letterheads, trade catalogs, and all sorts. We need to understand that incorporation of a company does not necessarily just start and end by merely filing your annual returns. It is bigger than that. That is the reason why the Corporate Affairs Commission is seeking to open the eyes of companies and third parties who deal with these companies to understand that the corporate veil covering this particular company or companies can be pierced at the point of exchanging correspondence. That itself saves the public the stress of trying to initiate a public search on CAC, trying to know who the face or who this company's face represents. Summarily,
got it. I got it. He did it. He really did it.
1st of August is around the corner. This is no time to begin to contend issues where there are not. All you need to do is to rejig your corporate setup from your letterheads down to your business complimentary cards, to your trade catalogs, your invoices and receipts, as the case may be. Because by this notice, third parties have already been put on notice as well, and they are already aware in their further dealings with your company. So obviously, they will be on their toes in doing further business with your company. So doing the right thing many times goes a long way